right, we'll start the afternoon then with the People versus Zachary Joseph Pellegrini, 226945 SM. All right, good afternoon. Mr. Pellegrini appears here this afternoon along with his attorney, Andrea Mashik-Lasala. The prosecution appears through Assistant Prosecutor Alex Saminsky. Along in the courtroom is the victim witness advocate, Connie Larson, along with Mrs. Danielson, the victim's mother here. I have received a sentencing memorandum from Ms. Mashik as well. I had received a motion. Did I not, Ms. Mashik?
No motion, Your Honor.
No motion, just the sentencing memorandum. All right. In regard to the matter then, did you receive a copy of the sentencing memorandum, Mr. Saminsky?
I did.
All right then. Did you also receive a copy of the pre-sentence report, Ms. Mashik, the most recent one, and go over that with Mr. Pellegrini?
Yes, Your Honor. There's nothing of a factual nature.
All right. In respect to your memorandum, your argument, is there anything you'd like to say on behalf of Mr. Pellegrini?
First of all, Your Honor, I have instructed my client to remain silent based on the matter to remain silent at sentencing. Additionally, we would ask that the court adopt the district court recommendations with exceptions to the issues that I in my memorandum.
All right. All right, Mr. Saminsky. Now, Mr. Pellegrini, you have the right to go last. It's called your right of allocution. So I'm going to ask Mr. Saminsky. I'll ask Ms. Danielson if she wants to say anything, and then we'll come around to you, and that's between you and your counsel what you decide to do. Mr. Saminsky.
Thank you, Your Honor. First, I'll just address the issues brought forth in the sentencing memorandum. I received this yesterday, just like the court did. I did not have an additional time to prepare any sort of written response. I think as far as HYTA is concerned, unless there's going to be a guilty plea entered here and not a no contest plea, that argument is essentially moot. The statute requires a guilty plea in order for any defendant to take advantage of it. Regarding the supervision fees, if the court grants a general delay, I think it's kind of a statutory gray area as to whether or not the district court can do that. Certainly, there's a statutory reason and legislative reason to mandate that the circuit court proceed with supervision fees because they're for the benefit of the Department of Corrections as outlined in there, and there's a specific savings clause about indigent defendants. But I don't think anything about that statute, I think Ms. Mashik recognizes that in the sentencing memorandum, overtly prohibits this court from collecting those supervision fees. It appears to be more of a mandate to the circuit court to collect them on behalf of the Department of Corrections in my reading. And as far as the last argument regarding the presence of Ms. Danielson based on some of the YouTube videos, etc., I would merely point out that the Michigan Constitution in Section 24 ensures the right of a victim or their guardian to appear at all court proceedings. And I think that being a constitutional right, there is a great burden on the defendant to prove that that would somehow be detrimental beyond the normal detriment that a defendant might face having to have a victim or their guardian speak on behalf of the victim in court. So for what it's worth, I would ask the court to reject that request. I think Ms. Danielson has every right to be here. It's guaranteed by our Constitution. Turning now to the case, I would ask the court to simply adopt the recommendations in the pre-sentence report. The court is very aware of the injuries that Mr. McWilliams suffered as a result of this assault. This court is very aware of the hardships he endured before any of this ever came about. and how his life was affected from the very inception by something outside of his control. And again, this was all part of a Cobb's proceeding that we previously had, so I think the recommendations are based on that, the court being fully aware of the facts of this case. I would ask the court to simply follow the pre-sentence recommendations, and I would leave any further time to Ms. Danielson for any comments. Thank you.
All right, in respect to issue 3 of your motion, then, did you wish to be heard any further, Ms. Mashik, concerning Ms. Danielson's right to participate here today?
Your Honor, I guess if the court is not inclined to adopt that, then we would ask that the court instruct Ms. Danielson to refrain from posting tweets or videos on Facebook making fun of a very serious matter, which is this court hearing. So I would ask that if possible, that the court strongly urge her to behave in an appropriate manner and not post funny videos of this proceeding on Facebook.
Honor, may I be heard?
You may.
Not to belabor the point, I don't think the court can order any of that. Ms. Danielson has a First Amendment right to say whatever she pleases, however distasteful or agreeable anyone may find it. She has every right to do that. She wasn't recording in this courtroom. She was utilizing a live stream. She's not violating any of the rules of this court, any criminal laws that I'm aware of, nor is she engaging in any behavior beyond simply posting on a social media platform, not even directly to Mr. Pellegrini. I think that falls squarely under her right for free speech, and ultimately, you know, it's not up to this court, and I don't think the court has the power to order her not to exercise that right. I think maybe simply an advisement that it shouldn't go too far and shouldn't be directed at him, because that could start bordering on a criminal offense. But certainly posting videos, whether anyone might find them tasteful or not, is well within her right. It's not harassment, it's not violating the criminal statute, and I believe that's her right under the First Amendment. Thank you.
All right, thank you. In regard to that particular issue, I don't believe that, one, you've supported this with any kind of law other than it's distasteful, in my opinion. And I think she does have a First Amendment right. How this differs from court TV or any of that other, you know, stuff, that garbage, I call it, that's available online, that's fine. But she hasn't recorded here in the courtroom. It is taken from a live stream. As to my personal opinion about it, I'm not sure that that really matters. I think that, you know, it's sad. The whole situation all the way around is sad. It's sad that everybody has allowed themselves to stoop to the levels of behavior that they have. And frankly, Ms. Danielson, I can understand you're angry. I can understand all that. I've watched the videos that Ms. Mashik is talking about, and you're a grown adult, you know, this is, you need to be setting an example on certain levels, and that behavior is frankly beneath you in my mind, but that's up to you. That's your right. If you want to post that, who am I? But I really wish everybody would just stay off of that social media platform. It causes people to do and say things that they would never do or say directly to people's faces. And, you know, it borders on harassment, quite frankly. And it's pervasive in our community. It's pervasive in our schools. I mean, look what's going on. Kids are coming home and committing suicide over things like this. This is real, people. This is real. And you guys, the steps that you took and engaging in the behavior that you did, that upped it a couple of notches. Social media plus on steroids. And it's just all very unfortunate. I'm not going to bar Mrs. Danielson from being here. She has a right to be here. Nothing that she has done has ever been disruptive in this courtroom. Distasteful or not, it's not going to bar her participation here today. And I deny that part of your motion. In respect to the issue of the sentencing, then We'll get to your issues 1 and 2 momentarily. We're gonna go back to now Ms. Danielson. Ms. Larson, this is Ms. Danielson's opportunity if she wishes to address the court. If you would get the, yes, thank you, the feed here. All right, Ms. Danielson, please state your name.
Sandra Danielson.
All right, Ms. Danielson, what would you like to say, please?
First, I guess I'll apologize for posting. I'll take those posts down. I'm assuming that it's the ones where they were handcuffed, and I do agree that was probably in poor taste. I do repost these videos so that my family and friends that are in the state can view them easily. It's just these videos, and I will take those ones down. That probably was disrespectful.
Thank you, Ms. Danielson. I appreciate that.
Mr. Pellegrini, I really hope you've learned from your actions that caused my son injury. I hope you can get your life on track. Last time we were in court, as your family left the courtroom, the two gentlemen showed me how angry they seemed towards me. I want to be clear. I know how difficult it is when your child acts in ways we really do not expect. I say child because no matter how old they are, they will always be our children. Perhaps you didn't intend on the angry faces you showed me. One thing I do know is without proper guidance, our children do not grow up to be the people they are capable of being. It has been almost a year since this assault on my son. I would hope by now you have been able to convey to your son how serious this crime was. He could have faced more serious charges and consequences, especially if my son would have died. I've heard people say his injuries weren't that bad. I'd like to know what that means. He has gone to more doctor's appointments in the past year than he has in his entire life. Mr. Thompson's attorney said that his client only punched Trenton 3 times. Mr. Loomis admitted to police he punched Trenton 5 times. I have pictures of at least 3 different blueprints on Trenton's back and shoulder. He had 2 holes in the top of his head, probably from steel toe boots. His other injuries, a broken nose, concussion, lacerated eyelid, broken teeth, were bad enough. His cognition has declined, and he has PTSD now that won't heal. I'm sure if your son were attacked by all these people, you would fight for justice just as I have. I have not been in court this past year because I wanted to be. I've been here for my son. Shortly after this assault, Trenton told me he didn't think any of these people would get in trouble. He felt it would just continue like it has for several years now. I needed to show my son how to fight for what's right. He told me he feels better knowing most of you were charged and faced consequences. He seems like he is satisfied with the outcome of all these defendants. My hope is he can also feel safe. I don't expect to be friends with any of you or your families. However, I won't be intimidated. I hope you convey to your son the right way to feel about this. Being angry at me and my family is not really appropriate under these circumstances. Thank you, Your Honor.
Thank you, Ms. Danielson. Mr. Pellegrini, is there anything you'd like to say here today?
Oh, Your Honor.
All right, Mr. Pellegrini, Ms. Mashik, Mr. Szymanski, Ms. Danielson, we've been down this path a number of times with your co-defendant. We've been down this path somewhat in respect to a Cobb's hearing that we had earlier. Regarding the issue of the sentencing. I think that the agreement that the court engaged in as we conducted the hearing, the Cobb's hearing, is the agreement that I am prepared and willing to stand by. I'm not going to give an alternative of the Holmes Youthful Trainee Act here. Excuse me, you're asking for a deferred judgment of guilt under 762 under the Youthful Trainee Act, correct? Yes. No, I am prepared to impose sentence as I stated that I would under the general delay of sentence statute. Mr. Pellegrini, that gives you an opportunity to demonstrate that this is an errant judgment that you will overcome by making the right choices for yourself and for all others in the period of time to come. There will be no early discharge from your 6-month term of probation. There's a $200 oversight fee. I think a term of probation one is appropriate given the fact he's going to give an opportunity to earn a delay of sentence status as opposed to having a conviction appear as a permanent part of his record. For that reason, the alternative of probation is appropriate, not only for his benefit, but for the benefit of society and making sure that he does complete the issues associated with his probationary terms as part of his rehabilitation as well as punishment. Fines and costs on count 1 are $640. Fines and costs on count 2 are $440. There is a $300 attorney fee assessment. The updated restitution amount is $2,973. That's jointly and severably between all the co-defendants. Crime fund fee is $75. The justice system assessment fee is $50 on each count. That's $1,755 plus the joint severable restitution. How does he intend to pay that then, Ms. Mashik?
He has $300, Your Honor, to put.
In respect to the issue, I didn't get back to that, number 2, your argument, number 2. At this point in time, I am going to implement a $200 oversight fee. I think the statute is unclear, and unless or until there's some directive otherwise, there is a direct benefit to Mr. Pellegrini by being supervised on probation as opposed to no probation, in that he has an opportunity to keep his record clear. And 2, there is the efforts and costs involved with supervising probation. So I am going to implement that. You are welcome to appeal that, Ms. Mashik.
Thank you, Your Honor.
And I will tell you, I'll look for more information on that issue as well.
Thank you, Your Honor.
I don't know why I have such an old memorandum. Mr. Pellegrini did serve 10 days, did he not?
It was 9 days.
9
We already
days.
had one credit.
Yes. All right. I am going to impose 30 days in jail. with 10 days immediately, credit for 10 days served. 10 days will be held in abeyance pending your successful completion of probation. And 10 days will be suspended for completion of 20 days of community service work. I'm going to order that you attend and complete anger management classes. In addition to the general terms of your probation, the following are specific to you. You must absolutely abstain from the possession or consumption of alcoholic liquor in any form whatsoever. You may not use, possess, or consume any non-prescribed controlled substances or prescription medicines that aren't prescribed to you. You must avoid all people that use, sell, or possess those items. Do you have a medical marijuana card? All right, then marijuana use and possession are prohibited. You're subject to random PBTs and drug screens while you're on probation. You may not engage in any harassing, intimidating, assaultive, or threatening behavior towards any person while you're on probation. You may not have any contact with Trenton McWilliams while you're on probation. You are not to be on the property of W5678 Swede Lane in Norway. You are not to use or possess any social media, including but not limited to Snapchat, Facebook, Instagram, etc. In respect to the matter then, do you understand the terms of your probation, Mr. Pellegrini?
Yes,
Did you understand the appellate court rights I gave the group earlier?
yes, Your Honor.
All right, Mr. Pellegrini, I hope that you're able to move on, make this something that is a learning lesson, something that you can use and spin to the positive so that you can ensure that the world is a better place after you've lived here.
Your Honor, with respect to fines, he is not able to pay them in full today. He does have 500. Could we ask for a payment plan after that on a monthly basis?
How much are you able to pay on a monthly basis and starting when?
200.
500 today, 200 a month starting April 15th and each 15th of the month thereafter until further order of the court. All right, then. Anything else today, Mr. Pellegrini?
No, Your Honor.
Ms. Mashik?
No, thank you.
Mr. Saminsky?
No, Your Honor.
All right, thank you, Ms. Danielson. Good luck to you. I hope you all are able to move forward.